that would negate this duty. Opposing counsel has submitted 2 policy considerations to negate this duty. 1, they said that this would open the door to, quote, trivial lawsuits, and 2, that this would create indeterminate liability. We refute this claim on 4 grounds. 1, policy concerns must be more than speculative. There has to be definitive potential for negative consequences. Opposing counsel has submitted no empirical evidence to substantiate this claim, and therefore, it is merely speculative. 2, we submit there is nothing trivial about the physical assault that can result as a result of people under the influence of alcohol. 3, the purpose of tort law is not only to provide compensation to victims, but to provide a deterrence to other potential tort feasors. Recognizing this legal duty would provide a powerful incentive, a powerful deterrence to all businesses who stand to profit from the sale of alcohol to take every precaution reasonable so that members of the community are not adversely impacted and so they don't wind up in the courtroom. So indeterminate liability, I challenge on this ground. And 4, recognizing a legal duty of care, as I have mentioned earlier, does not necessarily result in liability. The duty of care is one element of a negligence action. The plaintiff in any negligence action will still have to prove that there was a breach of standard of care, that there was a direct cause, and that the resulting harm was not too remote, and that there were damages that came as a result. So liability is, the scope of liability is narrowed when we take these other factors into account. Now, even if there are any legitimate negative repercussions that may arise, we submit that those are outweighed by the increase in safety to the community that will result. Every decision comes with costs and benefits, and it is our position that community safety under these circumstances takes precedence. This is also about behavior modification. The purpose of tort law is to shape behavior, and the imposition of a duty of care here, given the nature of this business, reflects an appropriate balance between the needs of business and the needs for community safety. And the courts can assist in striking the appropriate balance.
You're saying this is an appropriate balance. Should we give some thought to the fact that maybe commercial establishments, as my colleague mentioned earlier, might have difficulty getting insurance if it's that wide that they can be liable to anybody who's harmed by a person who has had alcohol? Or alternatively, if they can get insurance, I guess the cost of having a drink in a commercial hotel or bar might be extremely high because costs will be passed on to the customers. So should we take that into account, that it's something that society accepts, that there are commercial hosts who sell alcohol, and then presumably that's something that society wants?
Your Honor, we submit that this would provide an incentive to the commercial host to take every precaution reasonable. No commercial host wants to see insurance go up and don't want to lose business as a result of increasing costs of drinks. And this legal duty of care would provide that incentive that was needed, so that they do take every precaution reasonable.
And what's every precaution apart from looking that the person doesn't get intoxicated? You have to follow them out, make sure they don't have any weapon with them?
Your Honor, not necessarily. They could hire appropriate security, they could hire extra security, they could take some more proactive measures to provide numbers to taxis, they could provide better training to their staff.
It seems to me you'd almost have to walk them home, which may not be a bad idea.
And tuck them in.
In many of the relationships where a duty of care arises, such as that between a solicitor and a client, a lawyer, a doctor and a patient, a teacher and a student, we notice that power imbalances characterize these relationships. And this goes to the core of what it means to owe a duty of care. The appellants were in a position of power. The respondent, Mr. Donaldson, was in a more precarious position, and this is why the appellants have special responsibilities to ensure that the physical safety of community members are not compromised as a result of their business venture. This responsibility to take into account community safety does not end at the highway. Today it's the highway, tomorrow it might be a driveway. So it's the principle at stake here. And this category of duty of care is an important one because the sense of safety and security of the community as charter protected values are worthy of the strongest legal protection.
Thank you. Those are your submissions. Thank you. And you had reserved the right to reply still.
special relationships as defined in Stewart versus Petty. I would like to draw the court's attention to Stewart versus Petty, paragraph 48. It's tab 9 under the Book of Authorities.
What paragraph?
Paragraph 48. The counsel for the respondents read a quote from this paragraph that every person who enters a bar or restaurant is an inviter-invitee relationship with the establishment and is therefore in a special relationship with the establishment. If you continue the quote, it reads, however, it does not make sense to suggest that simply as a result of this relationship, a commercial host cannot consider other relevant factors in determining whether in the circumstances positive steps are necessary. The appellants feel that this was an important omission in this quote because it establishes the idea that simply a special relationship is not sufficient to establish a duty of care, that other relevant factors need be considered. We assert that factors such as the mode of transportation, in the case of Stewart Petty, this was somebody driving, or perhaps even the level of intoxication of the patrons is worth considering. That's all I have.
Thank you.
Thank you.
The court will reserve its decision in this case. And I believe now that we are invited to make a few comments to council. Perhaps I could start by congratulating you for having participated in this wonderful event. I am totally impressed. Unfortunately, I didn't get to hear everybody who was part of this on Saturday, but I'm totally impressed that you are up and pleading at this early stage in your career. So it looks like I'm going to see you again in a few years at the Supreme Court of Canada, because it looks like that's where you're going. I wonder if any one of my colleagues wants to make any particular comment. I'll have some as well.
Thank you, Justice Saron. Well, if at the risk of just repeating what was said, I find it hard to imagine that law students in their third month at law school could deliver a presentation of this quality. Congratulations. What amazing. Just a couple little practice points, if it's of any help. When you're dealing with an appellate panel, I think it's often appropriate to start off by referring to them collectively as justices. And justices, my submissions relate to that sort of thing. Or if you're dealing with addressing one particular judge in relation to their questions, you might say, well, in response to that, Justice Saron, I would say, or Justice Saron, I would say that way. In the Superior Court, though, where Judge Smith and I come from, it's easier. You just say Your Honor or Your Honor. It's easier. But it's nice to get it right. And there's another thing we listen for. When you're giving your submissions, we'd like to hear that you submit. So, justices, we submit that, or it is our submission that, and as opposed to, don't say think or assert. It's not a big deal, but it is just sort of an element of, if you like, a more practice, smoother ability to, if you submit. And there's also a rule of practice, a rule of professional conduct where you're not supposed to give your opinion to the court. So it kind of sounds like you're giving your opinion when you say I think and so on. Just a point. I love the level of enthusiasm that especially was